Time at large. What does time at large mean? When time can become at large? What are the consequences of time being at large? How to avoid project's time from being at large? What does time at large mean? Most construction contracts require the contractor to complete the works by a specified date or within a specified period of time. If the contractor fails to do so, and unless the extension to the completion date in respect of the causes of the delay, it will usually be liable to pay liquidated damages to the employer. Where, due to the absence or inadequacy of the contractual provisions relating to the time for completion of the works, the employer cannot insist on the contract completing works by a specific contractual completion date, time is said to be at large. Time at large usually means that there is no enforceable date for completion, and the contractor then only has an implied obligation to complete the works within a reasonable time. Two. When time can become at large? When there are no contract. If there is no contract, the time of completion will be set at large, since it being impossible to find a fixed completion date by which the contractor is to complete. However, if the works are carried out but no contract was entered into, then the performance of the works is not referable to any contract, the terms of which can be ascertained, and the time of completion will be at large. When there is a contract, but no completion date has been agreed. Where no completion date has been agreed in a contract, the employer cannot enforce a completion date of his choice and force the contractor to complete the works on that date. When the code for an extension of time for employer delays. Where no power to extend the time of completion for the employer-related delays is provided, the time of completion will be rendered at large. For example, in a contract, the power to extend time is provided, but where the wordings of the clause are not wide enough to include the delay, then the time will be set at large. Nevertheless, this situation will not arise as modern-day contracts contain retail-do clauses. When the power to extend time is inoperable. If the power to award O is not final and binding, and where the powers to extend time have not been followed, or the award was given under a collusion, then the courts will be not set time at large. This provision is only applicable where the powers to extend time have not been followed or used outside the administrative process contemplated by the contract. For example, by a third party rather than the engineer. Three. What are the consequences of at large? There will always be a dispute between the employer and the contractor about what is the appropriate time to finish. There will be no set date that can be considered effective for liquidated damages, and therefore the employer will lose the right to claim liquidated damages. This that the contractor is then relieved of all responsibility for the delay. The employer will still be eligible to claim general damages if the contractor fails to complete the works within a reasonable time. Only the employer will be able to recover its actual and proven losses resulting from the contractor's delays. While it is believed that an employer's claim for general damages cannot exceed the level of liquidated damages specified in the contract. Conclusion. If time becomes at large under a construction contract as a result of an employer's act of prevention, this is likely to cause problems for the contractor as well as the employer. A well-drafted extension of time clause will benefit both parties by maintaining a contractual time for completion, preserving the employer's right to liquidated damages and therefore giving the contractor certainty as to its financial exposure in the event of delays, and giving the contractor relief from its strict duty to complete the works on time in the event that delays are caused by specified neutral events.